Grubb versus Viridian Condominium Association. Go ahead, how are you? Okay, take your time. We're going to wait for these walks to get back anyway.
Good morning, Your Honor. John Craig Howell, Nashville Bar, representing the defendants of the Condominium Association. This is my motion for summary judgment. I've submitted it with two separate individual grounds for dismissal. Both individually are fatal to Mr. Grubb's complaint at the summary judgment phase. The first one is that Mr. Grubb does not have the 5% voting power required as a non-director member of the association to bring this lawsuit. It's a derivative action requiring under 4858-401 that he have that 5% voting power. It's undisputed that he is a single member, owns a single unit in the Viridian. It's undisputed that the master deed provides one vote per unit owner, and it's undisputed that of the 300 plus units, he is but one, and therefore cannot bring such a lawsuit. As I was preparing today to argue and look at potential counter arguments, I couldn't really find any. It's basically a statistical formula, 5% or not. Mr. Grubb is just one unit owner. In his response, he cites to the master deed a provision that lays out what is required to bring litigation against the HOA by a member. That's accurate. There is a process to do that. However, once you bring a derivative lawsuit like this, you're then under the statutory, the regulations in the statute of 4858-401. You need the 5% still. He's referring to the process of bringing a matter to the board of the HOA prior to filing a lawsuit. It's very common in governing documents of nonprofit and for-profit corporations. But again, the statute is very clear on this issue that you need the required voting power to bring this sort of lawsuit. It's undisputed that Mr. Grubb is bringing this lawsuit on behalf of the association relating to community property. It's an issue regarding fencing around the rooftop pool there. It's not his own unit or anything like that. He's bringing it allegedly for the the safety of the people that occupy and use that area.
Or particularly little children.
Particularly children, yes. And I'm not here today to argue whether it's safe, whether it's unsafe, get into the weeds on the facts of that. Just pure and simple, the first grounds here is that he does not have the standing to bring this lawsuit. The second issue is the statute of limitations issue. He's alleging a nuisance and the lack of proper fencing here. This is a 3-year statute of limitations. The fencing or lack of fencing, whatever it is, the issue, as he's alleged, has existed at least 10 years. I'll read from Mr. Grubb's deposition. I believe this was submitted with the motion. I asked, can you describe what your concern is for which you brought this lawsuit? In simple, we have this 5-foot fence on each side and a minimum of 43 inches for anything that's elevated. On the south end of the pool, there's walkways, places kids could play, and flower beds. Just go up, walking surfaces, and there's nothing to protect them from going over the end. It's unbelievable to me, but that's it. I followed up, when did you first notice this issue? I'd say at least 6 or 7 years ago. Later on, I asked, there's no difference in the condition now and back in 2007 when he first moved in. There is no change, I would agree. There is, I believe Mr. Grubb is raising that this is potentially a temporary nuisance, creating a new statute of limitations every day. That's more of an issue where operations or management result in a dangerous condition daily. For example, let's say there was a faulty lock on something in the condominium and management kept not fixing it or something like that. That's more of a temporary nuisance. What we're talking about here is the structure of the building that's been the same for 10 years plus now. It's fencing, it's permanent, it's much more in line with a permanent nuisance than what could be categorized as a temporary nuisance. Another way to determine whether something is a permanent nuisance is if it's at once capable of all the damage that can be created from that issue. So the damage that could happen here, people falling over the edge of the rooftop of the building, it's the same as it was in 2007, 2008, all the way up to the filing of this lawsuit. There's been no change in how severe that damage is or how severe this alleged issue is. It's simply the way the building is structured. And because of its existence for so many years, 3-year statute of limitations bars this lawsuit from being brought. And again, another way to address this, Mr. Grubb is proposing additional construction to the building, which is another categoric way of identifying this as a permanent nuisance. It's not simply something that gets fixed. He's requesting an additional construction, an additional improvement to the building, changing the property itself. So it's not a matter of management or operational issues. It's the structure itself that's been unchanged. So we presented these two issues. We think they're fairly straightforward. I don't plan to argue whether this issue is dangerous or obviously someone falling off a rooftop is dangerous. But this lawsuit, as we have it before us today, simply cannot move beyond the summary judgment stage for these two reasons. And the HOA may decide that they want to address, if there's an issue, they could address that. However, bringing the lawsuit and asking the court to force the HOA to do so is improper. And summary judgment should be granted at this point in litigation. Thank you.
Mr. Grubb? And apparently, Mr. Grubb, I think did you mail in a response or reply? No response has been filed. I thought there was.
Your Honor, I'm a rookie at this. Let me answer any question I can. I gave my response to them. I didn't know if I should mail something in or not.
Okay. If you have a copy, we'll take a look at it.
Do I have a copy of
You have the copy of your response?
Yes, I do.
We'll take it. Let's watch it. And you can talk about it. We just don't have, it's not in our system.
You can have all the documents, but number 2.
Okay, go ahead, Mr. Grubb.
Thank you, Your Honor. Great to be here.
Thank you.
Number one, I do own one unit, and I'm following the master deed. It says an owner may file a lawsuit. I want to go to the second part of the presentation. The Viridian rooftop pool deck has a 14-foot section of deck without a fence, without guardrails. And the construction, which is at the south end, and there are photographs of that, the last 3 pages, show wonderful places for kids to play. In 2006, if a family came, 2007, and brought their kids and family, they could have seen these 5 open-sided walking surfaces with no guardrails, with deadly drop-offs of 225 feet or 350 feet. But if you look at one of the next photographs taken by a drone camera, beautiful flowers, disguise and hide. this danger and are another enticement as a place to play. Also, that construction at the south end of the rooftop pool deck is an egress from the west side to the east side, back and forth. So in chaos, a time of chaos, lots of people could run down there and be traveling back and forth and up on it and decide to jump off. Who would know what they would decide to do? It will only cost under $10,000 to add the fence I'm requesting that would blend in with the fence that's already there. And indeed, Metro Codes is clear to call for a guardrail not less than 42 inches high that borders any kind of a drop-off more than 30 inches. I contend this is a continuing nuisance. One kid falls off today. If it isn't corrected, another one tomorrow. Who would know what the cost is?
Have you been in contact with Codes regarding this?
Oh, Your Honor, I went to visit Codes, and he gave me the reference, and I bought a code book, and it's in the document to show what the codes are in terms of walking surfaces, open-sided walking surfaces, and height, 42 inches or more. So it's clear that this is a subtle violation, or not so subtle violation of codes. I don't know how that happened, but I would like for this to go to trial and see what Metro Codes and Metro Pool says. I think that would be a great thing for this. But this is a deadly situation. We're talking about...
No, I'm saying that. Have you invited Codes up to take a look, to inspect the area?
We had another trial in which the Codes person came, and he got his tape measure out and measured that the fence was 5 feet tall, but there is no fence. And then when I quizzed him about this elevated play area and platforms, his comment was, "I don't teach human behavior." He also said that to me in his office. But, Your Honor, this structure is here. It's deadly. It's potentially deadly. And
so you're suggesting that Codes is not interested in enforcing this particular regulation?
Codes seem to have no interest. I've had the Metro Health has a pool section. I've had that person to come out and inspect it. And I was there with him personally when he inspected it. And a couple other people were present. And he said he would go back to his office and see if he could get together with Metro Codes and work out something. He wrote a letter back, which I had to have a copy of it, not in this document. And he said, well, you know, pool guidelines are there to keep children out of the pool. And I jokingly said to him, you're expecting aliens to come over this area where there is no fence and come in? I mean, it doesn't make any sense. Anyway, that hasn't happened. So I've gone to the board. I've met with the board in October of 2018. They have never told me what dangers they see or what they're going to do. They just said they'd get back in touch. And the thing that renewed my interest in this was we're talking about putting in grills and making this a more family-friendly environment. So I'm asking the court to deny this motion, dismiss this motion for summary judgment, and proceed to court.
Thank you.
In second. Thank you.
Your Honor, the code issue isn't really on the record at this point, but since you asked, the trial he's referring to is at General Sessions. We had representatives of Codes testify that everything was code compliant. Again, I didn't want to get into the weeds of that. I think we gave Your Honor two very good grounds to dismiss this lawsuit. Some of the other issues raised that aren't on the record, and there are no disputed facts that were raised in response to our statement of undisputed facts, but a cost analysis of what this addition to the rooftop would be. You know, there's no estimate from a contractor. There's no architect drawing this up. There's no other estimate other than Mr. Grubbs as to how much it would cost to fix this or to address this.
I did call the contractor and told him that the length of the fence would be at most 28 feet in all.
Go ahead and stand.
Oh, I'm so sorry.
No, that's okay. That's good.
I did call the contractor, And I had a different estimate, but anyway, he said it would be about $7,500, so that's why I said under 10,000. It's a very inexpensive resolution to continue the fencing that's already there that would provide us supreme safety. And again, all we gotta do is put in a few blocks.
This isn't on the record, Your Honor. I mean, his phone call to this contractor isn't before the court. So I would just, again, submit, Your Honor, that there are no disputed facts. In response to our disputed facts, I guess I didn't know they weren't filed, but he admits to them. He's argumentative in the responses, citing the dangers and that sort of thing, but they're not materially disputed. So based on that, Rule 56, I think, is lined up very nicely for you to dismiss this, Your Honor.
Okay.
Thanks.
All right. All right, based on the arguments of the parties, the evidence presented, and the entire record as a whole, the court does find that there is no genuine issue of material fact that the plaintiff has known about the existence of the alleged nuisance regarding the rooftop pool area of the Viridian since 2007, and the rooftop pool area of the Viridian has not changed since plaintiff first knew of the alleged nuisance. Pursuant to Tennessee Code Annotated Section 283105, a claim for an alleged nuisance must be brought within 3 years from the accruing cause of action. As plaintiff has filed his claim in 2019, the claim is barred by the statute of limitations. In addition, plaintiff has brought this suit as a derivative action pursuant to Tennessee Code Annotated Section 4856401. Plaintiff does not have standing to bring this suit pursuant to TCA Section 4856401, because plaintiff is not a director of the condominium association, nor is plaintiff's claims brought on behalf of 5% or more of the voting power. As such, plaintiff's claim must be dismissed. Court calls attached to the plaintiff. Motion for summary judgment is granted. Thank you all. If you would, please.